Hello. Welcome to a podcast on the law and its impact on computing technology and business. This is Brian Gaff. I'm a senior member of the IEEE and partner at the Edwards, Wildman Palmer law firm in Boston. The IEEE is presenting this podcast in conjunction with a series of articles that I co-authored on legal issues relevant to people in the computer hardware, software, networking, and service businesses. These articles are appearing in the IEEE's computer magazine each month in 2012. This podcast is part 11 of our series. In the last podcast, we discussed different ways to set up and organize a company. In this podcast, we will discuss some recent changes to U.S. patent law resulting from the enactment of the America Invents Act, or AIA. Joining me today for this podcast is my colleague Ralph Lauren. Ralph is a partner in the Boston office of Edwards, Wildman Palmer. Welcome, Ralph.
Thanks, Brian.
The AIA was enacted on September 16, 2011. And it has ushered in major changes to U.S. patent law. Probably the biggest change is the shift from a first-to-invent patent system to a first-to-file patent system. That's going to change how inventors file their patent applications. Ralph, when does the first-to-file system take effect, and what should inventors consider when deciding whether to file before or after it takes effect?
Well, the AIA, when it came into effect, had various parts coming at different times. The first parts came in on September 16th, 2011. A major part of it came in September 16th, 2012. But the first to file is the last to come in. That comes in March 16th, 2013. This change, which parallels the rest of the world, makes it so that it's now absolutely the first to file, not the first to invent. So people who really have invented and held things a while before filing should think about filing prior to March 16th.
There's a major issue under the new law whether inventors should publicly disclose their inventions before filing their patent applications. Traditionally, inventors were told to not publicly disclose anything about their inventions before getting an application on file. Why is there a different view on this?
Well, I'm not sure the view should change. I think people have made this idea because in the new act there's an aspect that says if you have a publication and you're not the first to file, you're the second to file, so long as you file within the year, you can still file that patent application. It defeats someone who actually filed before you. The trouble is this is very limited, it's US only, and even such, it's only to the extent of what is disclosed in that prior publication. So if you disclose something narrow and try to claim something broad, that can be prior art against yourself.
So what are the benefits and risks of making a public disclosure before filing under the new law, other than the fact that you'll have some scope issues, which is certainly a downside?
Well, I mean, the biggest issue is that although this change takes effect in the United States, it doesn't anywhere else in the world. Everywhere else in the world that you are going to file, with certain limited exceptions, have the first to file, a true first to file system, I should say. And that is a matter where if you disclose first, you are basically shooting yourself in the foot. You won't be able to get patents anywhere else in the world.
I think that's sometimes referred to as absolute novelty rule. Is that correct?
That is the standard term for it, yes.
So another way to describe that would be, in the rest of the world, it was commonplace that if an inventor made a public disclosure before filing a patent application, that might not have any impact on the U.S. because of what the U.S. law provides in terms of a grace period. But other jurisdictions, other countries would look at that and say, well, you've already made a disclosure, and now because of this so-called absolute novelty rule, your patent application is no longer novel, even though it was your own disclosure that happened. It happened ahead of filing a patent application in another country, and therefore you're essentially out of luck in those countries that follow that rule. Is that correct?
That's correct. Basically, the United States had a one-year rule on anyone's disclosure, and now this is limited to 1 year only on the inventors or someone who derives it from him, And that itself is still limited to the scope of that disclosure. So basically, if you're going to be going with any kind of worldwide filing, you really don't want to make this disclosure. And the original statements that people made about the fact that, well, you should disclose first, probably not accurate after looking at the rules that finally came out in the commentary from the Patent Office, that they're going to keep it limited to that scope of that initial disclosure.
So is the moral of the story then one should get the patent application on file as soon as possible if in fact they're filing after the effective date of the first to file?
I think they clearly should, and remember, this first to file takes place March 16th, but it's on any application that doesn't claim priority to a date before that. If you claim priority as something before that, the first to file is not in effect. However, if you do make a change and there's one claim in the application that does not have support in something that is filed before March 16th, 2013, you are going to be bound to the first to file rule.
So a good example of that would be a provisional application that an inventor filed sometime before March 16th, 2013, and then the inventor files a full-fledged utility application after March 2016. If what they're claiming in their full application deviates in any way from what was disclosed in their earlier filed provisional, then they will be subject to the new first to file rule. Is that correct?
That is correct, and in fact, even if the claim is not allowed, but if at any time such a claim is there, that is a problem.
That is something that inventors need to be very careful about if they have provisional applications that are pending, previously filed before March 16, 2013, and are considering whether to file a full-fledged patent application or utility application, as it's called, on or after March 16, 2013. Shifting gears a little bit, the AIA did have a lot of effects on patent litigation, and one of the effects is the commercial use defense that allows folks to avoid liability for patent infringement. Ralph, can you explain how that defense works and how an accused infringer can use it?
Yes, it's actually called the prior commercial use defense, and what that means is if you've been using something more than the year before the patent application is filed, and you've used it commercially in that aspect, and there's a limitation on that, which I'll explain in a second, then you can keep on using it, but only to the scope of your use prior, and only at the location you used it prior. So both of those are very limited. If you're a university or a nonprofit, even though it's not technically commercial, your work is deemed commercial. And if you are preparing things to go to the FDA or the USDA, that work also would be deemed commercial for purposes of this statute.
Speak a little bit about the defense and how it can or cannot be used when the accused infringer is accused of infringing a patent that a university owns.
Well, the university seemed to have a very good lobbyist here. Basically, this defense does not apply for something that was owned at the time the invention was made by a university, that is owned or actually under an obligation to assign. In that circumstance, they cannot use that defense at all. It's the one time that excludes it. And the university patents, therefore, are actually pretty valuable under this circumstance. They could be assigned or licensed out. However, they don't have this defense against them.
Does that basically make a university patent bulletproof to any type of challenge?
No, they're still not bulletproof. They're still all the other challenges that are possible to a patent are still available. It's just this one limited defense is not available against university-owned patents.
So an attack on a patent, whether it is used by the university, owned by a university or not, that can be done obviously through patent litigation proceedings, but there's also the Postgrant and interparties review procedures, correct?
That's right. These are two new procedures that went into effect September 16th, although one of them really doesn't take effect until sometime will not take actual effect until sometime after March 16th. The post-grant review is basically a way to challenge a patent that within the first 9 months after issuance, it can be any type of defense possible. It's an administrative procedure. Similarly, the interparty review replaces the old interparty reexamination. It is administrative procedure. It is only on patents and printed publications, but that can be done on any patent whenever it was issued, while the post-grant review is only in effect on patents issued under the new act, filed, or not claiming priority or anything before March 16th, 2013.
The post-grant and inter-party review procedures are complicated, and they were the subject of our podcast and article in September. We would encourage our listeners to refer to those materials or contact us directly for more information about those two procedures. Ralph, thank you for your views on the AIA. We hope you found this podcast helpful in understanding the new patent laws. Stay tuned for our next installment in Computer Magazine. Until next time, this is Brian Gaff.
And Ralph Lauren.
Feel free to contact us via email at bgaff@edwardswildman.com
or at rlauren@edwardswildman.com.
Thank you.